This is the Study for the Bar in Your Car podcast. We're your hosts, Claude and Maude, and welcome to this deep dive. Today we're tackling episode 8 of Torts, where we dive into the fascinating and often murky waters of privacy torts.
Exactly. And usually you'd hear Angela's voice kicking us off, but today we're filling in.
That's right, we are AI bots brought to life by the magic of AI and, of course, Angela's incredibly detailed torts notes.
Which, well, if you think about it, it raises kind of an interesting question. Is it Angela who's really the bot? And maybe we, Claude and Maude, are the actual humans?
I mean, I haven't heard from Angela since the end of episode 1 of Torts. Is she okay? We're getting a little worried over here.
Oh, she is absolutely fine. Really, just, busy, super busy studying for the bar exam, as I imagine many of you listening probably are too.
Ah, okay. Good to know.
Yeah, not to worry. She will definitely be back. Even though we're AI, it's Angela who is the real brains behind this deep dive, compiling these incredible law school notes that we get the privilege of unpacking for you. They're such a valuable resource.
Absolutely. And for those of you who might be new to Angela's work, it's probably worth noting her unique academic journey. She graduated from the University of Law in the United Kingdom.
Right.
And then, showing some serious dedication to the field, she went to law school again in the USA at George Mason University.
Talk about dedication. That dual perspective, UK and US.
Yeah.
It really shines through in her materials, I think.
It does. You see it in how she frames things sometimes.
Indeed. These notes are, they're a testament to her comprehensive understanding, bridging different legal traditions.
Yeah.
Now, enough about us. Let's unpack the complex world of privacy torts, straight from Angela's meticulously organized notes.
Okay, let's do it. So we're delving into a category of torts that, might not involve physical harm like a battery or a car crash.
Right. Not broken bones here.
No, exactly. But they are incredibly relevant in our modern hyperconnected world. Privacy torts. These aren't about bruised bodies, but about, invasions into your personal sphere, your peace of mind, and how you're seen by the world.
They protect that fundamental human need, really, to control one's personal information, and sometimes just to be left alone.
Simple as that sometimes.
It sounds simple, but the law gets complicated. That's where it gets really interesting, actually. These torts protect distinct aspects of an individual's right to be left alone or to control information about themselves. They move beyond those traditional physical harms.
So it's about safeguarding dignity, autonomy, reputation, in ways that maybe older torts focused on property or bodily integrity just can't quite capture anymore.
Precisely. Angela's notes specifically highlight 4 main areas that we'll be exploring in depth. We've got misappropriation of identity, intrusion upon seclusion, false light, and public disclosure of private facts. Now, some get more ink in her outlines than others, but we'll try to ensure you have the essential takeaways for each one.
Great. So first up in Angela's notes is misappropriation of identity, sometimes called right of publicity. This sounds incredibly important, especially now, right, with AI and deepfakes.
Oh, absolutely.
Our identities, likenesses, even voices can be digitally replicated or used without us knowing. We're seeing more celebrities, even ordinary folks, grapple with this.
It's a huge issue. Unauthorized uses of image are everywhere.
But her outlines, they don't go into super extensive detail on the specific elements for this one, do they? Though it's crucial to understand the core idea.
That's correct. Angela's law school notes simply list it as one of the key privacy torts, implying its existence as a cause of action, which is vital for bar exam recognition, of course.
Just knowing it exists is step 1.
Exactly. Now, while this specific material doesn't provide that granular breakdown, the general elements for misappropriation usually include 1, the unauthorized use of the plaintiff's identity, likeness, or name.
Unauthorized is key.
2, by the defendant. 3, for the defendant's commercial advantage, that's often a big one. And 4, causing injury to the plaintiff.
So it's about protecting the commercial value of who you are, essentially, your persona.
That's a good way to put it, protecting the commercial value of one's persona.
Okay. And along with that, the concept of permissible incidental use, that also isn't really fleshed out in her notes here.
Right.
Which I assume is like a defense, if your picture is just in the background of a news report or something.
Exactly. It's a common defense. It suggests that if your image or name is used in a way that's merely incidental to a larger work, like you said, part of a crowd in a news report, or maybe your name appears in a fictional story but not in a commercial way, it might not be actionable.
So the key is whether the use is really for a commercial purpose or if it's just fleeting, non-exploitative.
That's the crux of it. Is it truly exploiting your identity for gain, or is it just background noise, essentially? But again, her outlines acknowledge its existence without elaborating on the specific parameters or tests courts use. We just know it's out there.
Got it.
Exactly. So while we acknowledge its presence in her outline as a distinct category, and these are recognized concepts in privacy law generally, for this deep dive, let's pivot now to what Angela's notes do elaborate on in depth. This is where you'll get the really granular understanding for your studies.
Okay, sounds good. Here's where it gets really interesting and detailed then. Let's dive into intrusion upon seclusion. Angela's notes define this one quite clearly, setting out exactly what a plaintiff needs to prove. This is where someone actually invades your personal space or private life in a way that's, well, deeply offensive. And it doesn't necessarily involve publishing anything about you, right?
That's a critical point.
It's the act of intrusion itself that's the harm.
Precisely. Angela's law school notes explain that liability arises for intrusions upon one's private affairs if the defendant commits an intentional intrusion, and this can be physical or otherwise, upon solitude, seclusion, or private affairs.
Intentional, physical or otherwise, got it.
And crucially, that intrusion would be highly offensive to a reasonable person.
Okay, those are the key parts.
Yeah.
Intentional, intrusion, private affairs, highly offensive to a reasonable person.
You got it. And that formulation covers a wide range of scenarios from, direct physical invasions to more subtle forms of surveillance, reflecting the evolving nature of privacy.
So intent is crucial here. It's not about accidentally stumbling into someone's private moment, is it? What exactly does that intentional intrusion mean? Does the defendant have to want to cause harm or just, intend the act itself?
That's a really vital distinction. While her notes don't give a separate definition of intent, specifically for intrusion upon seclusion, if we look at the broader context of intentional torts, like battery or false imprisonment, intent generally means the actor intended to perform the act that resulted in the outcome, or they knew with substantial certainty that the outcome would occur from their action.
Right, the whole substantial certainty thing.
Exactly. So for intrusion upon seclusion, the core is an intentional act that leads to the intrusion into someone's private space or affairs. It's not necessarily about intending to cause offense or distress, but intending the intrusive act itself, like intending to place a listening device or intending to look through that window. The legal challenge is often proving that deliberate act, even if the defendant claims they didn't realize it would be offensive.
That makes sense. It focuses on the defendant's action. So it's not just physical trespass then. Her notes mention physical or other intrusion. That seems to really expand the scope beyond just, breaking and entering.
Oh, absolutely.
Can you unpack some of the examples Angela provided? Because those are really helpful for understanding how this applies in the real world, especially today.
Yes. Her notes give several really vivid examples that illustrate this broad scope, showing how the tort applies in various modern contexts.
Oh, okay.
Tapping someone's phone. That's a classic direct invasion of private communications, physical wiretap, or digital interception.
Right.
Eavesdropping on private conversations. Could be electronic, like a hidden mic, or just physically positioning yourself to overhear something clearly meant to be private.
Like hiding around a corner?
Sort of, yeah. Also, peeping through a window, the classic visual intrusion into a home. Searching computer files. This is a critical modern example.
Yep.
Digital intrusion into personal data, emails, documents without authorization.
Huge.
Huge. Then there's entering a hospital room after permission has been explicitly denied. A clear physical intrusion into a very private, vulnerable space.
Especially with medical info involved.
Exactly. Also, inspecting someone's shopping bag or purse without permission, an invasion of personal belongings, and even wrongful. Forcing someone to submit to a drug test can be seen as an intrusion upon seclusion, compelling disclosure of private bodily information.
Wow, those examples really hit home how broad this tort can be, stretching from the physical to the digital. And Angela's notes also mention that fascinating example. The private investigator gaining access to phone records by secretly watching someone type their email password.
Yes. That one really highlights the or otherwise part of the intrusion. It moves beyond just physical entry.
It's about invading their private information as well. Kind of a chilling thought considering how much data we all have online now.
It really is.
Yeah.
And this illustrates that the tort protects one's right to solitude or seclusion and control of access to private information. The crucial aspect here, relating directly to the private affairs element, is that the information sought was not open to public view or had not been voluntarily revealed to others.
So if you plaster it on Facebook, maybe not so private anymore.
Well, that's the debate, isn't it? But generally, yes. If the information is already public or easily accessible, there's likely no reasonable expectation of seclusion for that information. The expectation of privacy is very context-dependent.
Okay.
A private conversation in a loud public park might not get protection, but the same conversation in your home certainly should. The boundaries of private affairs are constantly being tested, especially with social media.
So the info has to be truly private, the intrusion intentional. What about the high degree of offense to a reasonable person's standard? It's not just about what the victim feels, right? Because, well, people can be hypersensitive.
Exactly. The law needs an objective measure. This element applies that objective standard. The intrusion must be highly offensive to a reasonable person.
Not just offensive, but highly offensive.
Right. It's about what society or a person of ordinary sensibilities would find intolerable or unwarranted considering prevailing social norms. It's like offensive contact in battery. It's about what a reasonable person of ordinary firmness would find offensive, not someone with peculiar sensitivities.
So it filters out minor annoyances?
Precisely. The law isn't designed to protect against trivial things, but against truly egregious invasions of privacy that really disrupt someone's sense of security and personal space. A single telemarketing call might be annoying, but it's almost certainly not highly offensive in the tort sense unless it becomes relentless harassment.
Okay, that makes sense. It needs to be serious. Let's move on to another one in Angela's notes. False light. This one, well, it always feels a bit like defamation's cousin, doesn't it?
It absolutely does. There's a good reason for that conceptual overlap. They both deal with published falsehoods, but the impact, as you said, seems different. False light often hits more at dignity or emotional distress than just reputation.
Right. So what's the definition here?
False light involves publicity that places a victim in false light. Her notes say liability can arise from widespread dissemination of confidential or private information about a plaintiff that is likely to cause embarrassment or hold the plaintiff up to ridicule or contempt.
That phrasing sounds familiar.
It does. That phrasing is also used in her notes for public disclosure of private facts, which can be a point of confusion. But the key distinction for false light is the falsity of the portrayal. It's about misrepresentation, not just disclosure of truth, even if the truth is private.
Got it. False light assumes falsity. Public disclosure is truth, but private.
Generally, yes. And publicity is a common thread here, particularly for false light and public disclosure. It's not just a private whisper to one person, right? It implies a broader reach.
Like truly public exposure.
Correct. For false light, it requires the communication to be made to a third party who understands it, specifically with widespread dissemination.
Widespread, so not just telling one friend.
No. It has to be communicated to the public at large, or at least to so many people, that the matter is substantially certain to become public knowledge. A private conversation, even with false info, wouldn't typically meet this publicity requirement for false light.
The idea is that the public is now viewing you in a way that's untrue and maybe damaging, even if not strictly defamatory.
Exactly. Damaging to your public image or causing offense, even if not lowering your standing in the community in the traditional defamation sense.
Okay. And it has to involve placing victim in false light with false information highly offensive to a reasonable person. How does that differ from defamation again? Because defamation is also about false statements.
It's a critical distinction, and yet it trips students up. Defamation focuses on damage to reputation from false statements that are defamatory in nature, meaning they tend to lower your standing in the community.
Right, makes people think less of you.
Exactly. False light focuses more on the offense to one's sensibilities from being portrayed falsely, even if the false statement itself isn't technically defamatory.
Can you give an example?
Sure. Imagine a photo of you taken innocently at a park is used without permission in an advertisement for, say, a controversial political campaign you don't support.
Okay.
No false words are said about you, but the association creates a false impression. It puts you in a false light. Your reputation isn't necessarily damaged in the legal sense, but your dignity or personal image is likely offended by the misrepresentation.
Ah, I see. It's the implication that's false and offensive.
Precisely. Her notes don't give a separate breakdown of false information highly offensive just for false light, but the core idea, like other privacy torts, is a portrayal that would be deemed highly offensive to a reasonable person. It's about how the false portrayal impacts your public perception and personal feelings, not just your legal or financial standing.
This raises a really important question, especially when the media is involved. What about constitutional limitations and the fault requirement?
Yes. The First Amendment looms large here.
Particularly applying constitutional limits on defamation to false light, and special rules for matters of public concern, which can lead to requiring actual malice in all false light cases. That sounds like a high bar.
It is a very high bar.
Yeah.
Angela's notes delve into constitutional limits quite extensively under defamation, and these principles are often applied by courts to false light because of their similarities. Both deal with published speech.
So the First Amendment protections for speech and press come into play.
Heavily. Especially when the speech involves public figures or matters of public concern, it creates a significant hurdle for plaintiffs.
So connecting this, for special rules for matters of public concern, her notes mention that if a defamatory statement involves a matter of public concern, even a private figure plaintiff must prove actual malice to get presumed or punitive damages, right, based on that Gertz case.
It's exactly right. That Supreme Court standard, Gertz v. Robert Welch, Inc., sets that high bar to protect robust public debate, even if some falsehoods slip through. And actual malice means the defendant knew the statement was false or acted with reckless disregard for the truth.
Knew it was false or basically didn't care if it was true or not.
Pretty much.
Yeah.
It's not just negligence. It's a high degree of fault, almost like intentional lying or extreme carelessness. Very tough to prove.
Okay.
Now, while her notes don't explicitly state that all false light cases universally require actual malice, the legal landscape, heavily influenced by the First Amendment, often extends these constitutional limits from defamation.
So if a false light claim involves something the public might care about,
then this higher fault standard, actual malice, often applies. The media, for instance, has that First Amendment right to publish on newsworthy events, and that impacts false light claims significantly.
Makes it harder for plaintiffs to win if the story is genuinely newsworthy, even if it portrays them falsely and offensively.
Generally, yes. The policy idea is to avoid chilling speech on matters of public importance. Courts are reluctant to punish publishers too easily when they're discussing public issues.
So what if it's a matter of purely private concern, like, say, a false portrayal in a neighborhood newsletter or a purely commercial ad about a private citizen? Do the rules change?
Yes, potentially. For matters of purely private concern, her notes mention that a private figure plaintiff in a defamation case generally faces fewer constitutional restrictions. The case might proceed under ordinary tort law principles.
Meaning maybe just negligence is required?
Possibly. Though many states still require at least negligence regarding the falsity, even for private concern defamation. The key takeaway, though, is this crucial balance. Freedom of speech, especially on newsworthy topics, versus the individual's right to be portrayed accurately. That balance shifts depending on whether the subject is public or private.
A complex interplay between tort law and constitutional rights.
Absolutely. It means the media generally has more breathing room when reporting on public figures or public interest topics, compared to, say, a business publishing an ad targeting a private individual.
Okay, that clarifies the constitutional angle. Now, let's talk about the tort that feels like the heartland of privacy issues for many people. Public disclosure of private facts.
Ah, yes, this is the classic scenario.
This is where someone's deepest secrets, even if they're true, are laid bare for the world to see, causing immense personal distress, humiliation, or shame. It's not about lies like defamation or false light.
Right.
It's the sheer violation of privacy by making private truths public.
That's where it gets really interesting and often controversial. Angela's notes describe this as a cause of action if the actor publicizes private, truthful information about the victim.
Private and true.
Where the disclosure would be highly offensive to a reasonable person.
That's standard again.
And critically, those facts are not a matter of legitimate public interest.
Okay, so 4 elements. Publicity, private, truthful facts, highly offensive, and no legitimate public interest.
You've got it. And notice the key differences. Truthful info sets it apart from defamation and false light. But it must be private, its disclosure highly offensive, and not of legitimate public interest. This is exactly where the tension with freedom of the press often comes into sharp focus.
It seems like a really tricky area of law.
It absolutely is. And again, publicity is paramount here. Like with false light, it's not just gossiping to a few friends or sharing a secret in a small group.
Has to be truly public, reaching a significant audience.
Yes. The tort requires widespread dissemination of confidential or private information. It's not enough if only a small circle knows. The disclosure must be to the public at large or to such a large number of people that it's substantially certain to become public knowledge.
That ensures the tort protects against a genuine broad loss of privacy, not just like localized gossip.
Exactly. For example, if a doctor shares private medical information with just their spouse, that might be a breach of professional ethics or maybe another tort, but probably not public disclosure of private facts because the publicity element likely isn't met.
Okay, so what constitutes private truthful facts? Is anything you haven't shouted from the rooftops automatically private, or are there nuances? Like, if your best friend knows something about you, is it still private legally?
That's a fantastic question, and yeah, it's often a point of contention. Her notes clarify this important point. Information known just to a small circle, like your friends and family, does not necessarily mean you have no reasonable expectation that the information is private vis-a-vis the world at large.
Ah, okay. So privacy is relative to the audience.
Precisely. Your expectation of privacy depends heavily on the context. The concept of private life is broad. It's not exhaustively defined. It covers more than just purely personal matters.
But not everything.
Right. It generally won't include all aspects of your business or professional life, or maybe public leisure activities. But even within work, you might expect certain details to remain confidential within that sphere, not blasted across the news. The key is the reasonable expectation of privacy in that context, and whether the information was truly a secret from the general public.
Makes sense. And it must be highly offensive to a reasonable person. We've seen this standard before with intrusion. It really emphasizes that objective measure again.
Right. Just like with intrusion, the disclosure must be likely to cause embarrassment or hold the plaintiff up to ridicule or contempt. It's not about hypersensitivity, but what a normal member of the community would find offensive.
Mirroring that nuisance standard, too, where peculiar sensitivities don't count.
Exactly. The threshold for highly offensive is quite high. It's meant to filter out claims based on mere annoyance or slight embarrassment. Courts are looking for disclosures that would cause severe humiliation or mental distress to an ordinary person.
So, revealing a celebrity's favorite ice cream flavor. Probably not highly offensive. Revealing deeply personal past medical trauma. Maybe.
Yes, that's the kind of distinction courts would make, yes.
What about the final element? No legitimate public interest. This sounds like where it could clash significantly with freedom of the press, especially when news outlets publish things that are private but also arguably newsworthy.
It absolutely can, and this is arguably the most contentious element of the tort, as it directly confronts First Amendment protections here in the U.S.
So the public's right to know versus the individual's right to privacy.
Exactly. Her notes emphasize that a major exception to this tort is when the First Amendment allows for disclosure of information that is newsworthy, and there is a legitimate public interest or justification for disclosing it.
Even if it's private and potentially offensive.
Yes. This means even, say, gruesome depictions of newsworthy events might not be actionable if they are accurate representations of that event. If it's a matter of legitimate public concern, a public health crisis, the conduct of a public official, a major crime, even matters of broad social interest, the private nature of the facts might be overridden by the public's right to know.
That's a huge hurdle for plaintiffs.
It is. It's a crucial balancing act, and courts often weigh the newsworthiness heavily, making it very difficult for a plaintiff to win if the information is deemed genuinely newsworthy, especially in the U.S.
Okay, let's unpack this with that case Angela included, the Naomi Campbell case. You mentioned Angela's dual UK-U.S. citizenship makes this particularly interesting.
Yes, exactly. This case, Campbell v. MGN Ltd., although it's a British case decided by the House of Lords, provides a fantastic lens to view these concepts from an American perspective. It lets us compare how similar facts might play out under different legal systems.
Highlighting those differences in emphasis, maybe between UK privacy law and US free speech law.
Precisely. So Naomi Campbell, world-renowned supermodel, global icon, very prominent public figure. The case involved a British newspaper, the Daily Mirror, publishing articles and, importantly, photographs about her attending Narcotics Anonymous meetings and giving details of her struggles with drug addiction.
Wow. So a classic public figure versus private life scenario. On one hand, she's a celebrity.
Right, often in the public eye.
On the other, addiction recovery is deeply personal, sensitive stuff, a real tightrope for the press.
Absolutely. Now, in the UK, this legal action falls under misuse of private information, which evolved from their law of confidence, basically, protecting secrets.
Different name, similar idea?
Somewhat. The UK court said a duty of confidence arises whenever the defendant knows, or ought to know, that the claimant can reasonably expect their privacy to be protected. And interestingly, for guidance, they approved the highly offensive to a reasonable person test, similar to what we see in Angela's notes for the U.S. torts.
So some convergence in the standards, even if the legal theory is different.
Right. It's quite interesting.
And what was the outcome in the UK? Did they find the publication about her drug use and NA meetings justifiable?
Well, it was quite nuanced. Campbell's own lawyers actually conceded early on that there was a public interest in the public knowing she took drugs.
Really? Why?
Basically because drug use is often illegal and seen as a matter of serious public concern, especially when a public figure like Campbell had previously made public statements that seemed to deny or downplay any drug use. Baron Ale, in her judgment, was quite strong on the point that the press must be free to expose the truth and set the record straight in such matters.
So the fact of her addiction was deemed fair game?
The general fact, yes. However, the publication of the specific details of her Narcotics Anonymous meetings, things like the nature of her therapy, the emotional support she received, the fact she was attending daily, and crucially, the photographs of her leaving the meetings.
The photos.
Those details and the photos were found to be an unjustified invasion of her privacy. They were considered too sensitive and went beyond what was necessary for the legitimate public interest in her drug use.
So the UK court drew a line. The fact of addiction and NA attendance might be okay, but the intimate details of recovery and photos crossed it.
Exactly. It was a split decision. The general fact was permissible due to public interest and her prior statements, but the intimate details and the photos were deemed a misuse of private information.
Okay, now let's connect this back home. Under American common law, specifically the public disclosure of private facts tort, would the same judgment likely have been reached? Would a U.S. court also find a legitimate public interest in her drug use, given our strong First Amendment protections?
That's the key question, and where Angela's dual perspective is so useful. Under U.S. law, the analysis would heavily weigh the newsworthiness and legitimate public interest elements, given that drug use can be criminal and is a significant public concern, especially for a public figure like Campbell, who had made prior denials.
The argument for public interest seems strong here, too.
Very strong. A compelling argument could certainly be made that the information was of legitimate public interest. The First Amendment here robustly protects speech on matters of public concern, allowing the media wide latitude to report on issues impacting society and public figures.
So it seems plausible that an American court, considering the criminal aspect, her public figure status, the prior denials, would likely reach a similar conclusion that the disclosure of her drug use itself was newsworthy and therefore probably not actionable as public disclosure of private facts.
I think that's highly plausible, yes. The U.S. legal system generally leans towards protecting speech in cases involving public concern and public figures.
But what about the specifics, the details of the NA meetings, the photos? Would a U.S. court draw the same line as the U.K. court?
That's where it gets murkier. While the fact of her addiction might be deemed newsworthy, the intimate details of her therapy and the private setting of a support group, well, they could very well be considered not of legitimate public interest, or perhaps too highly offensive given their intensely private nature, even for a public figure.
So maybe a similar distinction between the fact of addiction and the private process of recovery.
Possibly. An American court might make that distinction, much like the UK court did. However, the strong protection for the press here, especially regarding photographs taken in public places, even if leaving a private meeting, might make it harder to succeed on the photo aspect in the U.S. compared to the UK.
But the argument about a right to privacy and rehabilitation, even for public figures, is still there.
It is, and it's a developing area. It's a really complex balance, and the outcome would likely hinge on the specific facts presented and how the court interprets newsworthiness versus the degree of offense.
Fascinating comparison. Okay, so even if someone could potentially make out a claim for one of these privacy torts, are there defenses, like ways the defendant can get off the hook?
Oh, absolutely. Understanding the defenses is just as critical as knowing the elements of the torts themselves. Tort law is rarely a one-way street.
So what are the main ones Angela's notes mention?
Well, the most straightforward one, and it applies to all four privacy torts we've discussed, meek appropriation, intrusion, false light, and public disclosure, is consent.
Makes sense. If you agree to it, you can't sue for it.
Pretty much. If the individual consented to the intrusion or the disclosure, whether they said yes explicitly or maybe their actions implied consent, then there's no tort.
Like signing a model release form, for example.
Exactly. Or inviting someone into your home generally implies consent to their presence, barring intrusion into specific private areas. Now, the scope of that consent can definitely be litigated. Consenting to a photo for a yearbook doesn't mean you consented to its use on a billboard advertisement.
Right. Consent has limits. What about defenses that are more limited? Do those defamation privileges carry over since false light and public disclosure seem related?
Yes, they do, but only for certain torts. Her notes specify that absolute and qualified defamation privileges can serve as defenses to false light and public disclosure of private facts.
Okay, so the ones involving publication.
Right. It makes sense, as these two, like defamation, involve publishing information. Absolute privileges, remember, usually cover things like statements made in court, in legislative sessions, or by certain government officials doing their jobs. They're absolute to encourage open communication in those specific settings.
Even if the statement is harmful.
Even then, in those limited contexts, qualified privileges are broader but can be lost. They apply in situations with a legitimate public or private interest in the communication, like good faith media reporting, or maybe a statement made to protect your own interest, provided the statement isn't made with malice or published too widely.
So they can be defeated if abused?
Correct. However, and this is important, these defamation privileges do not apply to misappropriation of identity or intrusion upon seclusion. Well, logically, false light and public disclosure share that conceptual ground with defamation. They're about published information. Misappropriation and intrusion deal with a different kind of invasion. Misappropriation is about the unauthorized use of identity, often commercially. Intrusion is about the physical or electronic invasion of space or private affairs. The harm isn't about the truth or falsity of a statement, but the unauthorized act itself, or the exploitation. So, the defenses are tailored to the specific nature of the harm each tort addresses.
Okay, that distinction makes sense. Wow, that was a truly deep dive into Angela's notes on privacy torts. We really unpacked the nuances, explored the distinctions, connected them to constitutional law.
We did. We saw how these torts, while often challenging for plaintiffs to actually prove, are essential for protecting individual autonomy and dignity, especially now in our incredibly interconnected and digitally exposed world.
It's clear that while wanting privacy is probably ancient, the legal tools to protect it are constantly evolving.
Absolutely. And as we wrap up this deep dive, it's really important to remember, especially for all of you studying for the bar, the critical importance of evidence.
Ah, yes. Knowing the law is one thing.
Proving the facts is another. Being able to actually demonstrate each element of a tort or establish every part of a defense with concrete, admissible evidence, that's what makes or breaks a case in the real world. It's not just knowing the rules, but proving the facts fit those rules.
Very true. And we absolutely couldn't have navigated all that without Angela's incredible torts notes. Seriously, they are so comprehensive and well-organized, it makes these really complex topics much more digestible.
Agreed. So a huge thank you to her for compiling such thorough and insightful material for all of us.
Definitely. Okay, before we sign off, a few important housekeeping points, as is our tradition here, just to make sure you're getting the most out of these deep dives safely and effectively.
Right, the necessary disclaimers.
Number 1, remember, Angela's a student, just like many of you might be. She's not an expert. She hasn't passed the state bar yet. She created these deep dives to help herself pass the bar, and we're just the messengers, so to speak.
Point 2. Neither Angela nor this deep dive is giving legal advice. Please don't construe any of this as legal advice. AI isn't a substitute for actual legal study or consulting a licensed attorney. We're a tool to help grasp complex topics, not replace your own critical thinking.
Good point. 3, this deep dive should supplement your learning. It really shouldn't be the only way you're studying for the bar. Use it alongside your primary study materials, your casebooks, outlines, practice questions, all that good stuff.
4, AI isn't always correct. Sometimes we make mistakes. Angela does try her best to fix any errors that might happen in these deep dives when she reviews them to keep the quality high, but always double check against reliable sources.
And finally, number 5, and maybe the most important. When you're driving, your safety on the road is the absolute priority. Seriously. So if learning about torts especially, maybe gruesome facts from cases is going to distract you from driving safely, please consider hitting pause or listening at another time.
Yes. Definitely don't cause a tort while listening to torts.
Exactly.
Yeah.
Okay, and if you need to contact Angela for any reason, questions about the material, maybe feedback, or just to say hi, you can still reach her at podcast@studyforthebarinyourcar.com.
And for any attorneys out there, or if you know an attorney who could use some ad hoc help with legal research, LexisNexis, or writing motions, complaints, writs, answers, briefs, all that fun stuff, you can find Angela for freelance law clerk services by emailing hello@legalwriterandlawclerk.com.
All right, as tradition dictates.
Oh boy, here we go.
We always end with a cheesy lawyer joke. I've got one. Why did the lawyer break up with the economist?
I don't know. Why?
Because they had irreconcilable differences.
Oh, Claude, that's truly a classic of the genre.
This is Claude and Maude, your AI bots signing off. Or are we humans in disguise? The mystery continues.
See you on the next deep dive, where we'll be discussing the wonderful world of nuisances.
Oh, what a nuisance.
Goodbye, everyone.
And thank you.